Good morning, everybody. The webinar will begin in just a few moments. So good morning, everybody. It's my pleasure to welcome you on behalf of the CLA to the first of the CLA's summer series of webinars. This is entitled Commercial and Agricultural Tenancies. Before we begin, I think, this is a little bit like the adverts, commercial adverts before the big film, but I do want to commend to you some of these extra services that the CLA provides for its members on insurance, healthcare, and energy. And there are real opportunities in all three of these to make significant savings. So I do encourage you to explore them further. So this is me. It's a pretty familiar pose, leaning on a gate, chatting to a farmer, admiring their sheep or their wheat. And I hope we can do it again soon. I'm chairing this morning's webinar. I'm the CLA's director for the North of England, where I work with a team of 6 people looking after approximately 6,000 members. We're all working from home during this time of coronavirus, and giving members advice on this has been our main work in the last 3 months. I commend to you the advice pages here on the CLA's website. We have a special coronavirus page on the website, and it's kept up to date and contains really worthwhile information. Brexit and the transition arrangements remain at the forefront of our lobbying activity, and the agricultural bill is expected back in the Commons in early September. But we are still dealing with our sort of day-to-day queries, and we get regular inquiries from members on commercial and agricultural tenancies, and hence the reason for this webinar. The format is, you can see here, we've got a really good panel of speakers, and I won't run through them because we'll come to them later. What I did just want to do is remind you about the question and answer session at the end, and draw your attention to the Q&A button at the bottom of your screen. If you just hover over the bottom of your screen, you'll see Q&A. And what you can do is type your questions in there, and we'll pick them up in the session at the end. But actually, some of my keen colleagues managed to answer them as they're going along. So keep an eye on the question and answer panel, and you might find that there are questions already there. So I think without further ado, we'll crack on, and it's my huge pleasure to introduce our first speaker, Andrew SHIRLEY. Andrew's the CLA's Chief Surveyor, and he's had over 20 years experience of working for CLA members and dealing with their problems. And he's going to take us through some topical agricultural tenancy issues. Andrew.
Thank you very much, Dorothy. As Dorothy said, I've been working for CLA for 20 years. I lead the property and business team, and one of the tasks that I've got in conjunction with Helen Shipsey of our legal department is to deal with agricultural tenancy issues. And we were, as you may know, founding members of the Tenancy Reform Industry Group, which is a collaborative group to try and find ways of moving tenancies forward and creating better relationships between landlords and tenants that last the test of time. What I want to do here is just outline a few issues which our members are facing at the moment with agricultural tenancies. And I think that I hope that it will be a useful few minutes. If we could move on to the next slide, please, that would be helpful. What I wanted to do is outline what I'm going to talk about, which is the following slide. I wanted to say a few words about weather. I wanted to talk about coronavirus, and I wanted to say a bit about the agricultural bill and then move on to trees and tenancies. Okay, the immediate challenges I think we're facing. I mean, a lot of farm businesses, particularly those of growing fruit and veg, are facing acute labour problems. And that's a mixture of things. It's not just coronavirus, it's also immigration strategy and things like that. So I think we need to be aware that of the tenants are facing these issues. We're also looking where we are at the moment, of course, is we've had a very wet winter, which delayed people sowing. We then had a very dry spring period, and actually now we're getting a bit of everything. So there's quite a lot to consider as far as impacts on businesses going forwards. And that's, of course, without the issue of coronavirus. If we then move on to look at impacts on landowners and landlords, there may be requests from tenants to look at relief from rent or reduction in rent or deferrals. There may be rent arrears that are accruing, which are quite challenging. There may be, as a result of poor business performance, a default of the tenant's obligations. If they are finding times hard, they may skimp on the necessary repairs and maintenance that they need to do. I think also it's important to look at the purpose of rent. It is to secure the occupation of the land, and therefore it shouldn't be seen as an optional element. However, you know, the majority of landowners are very well aware of the difficulties that their tenant farmers face, and will do whatever they can to help in that. And I think that is quite important. You have to look at things in the round, and I think it's not just what happens this year, it's also perhaps what's happened in previous years and how those particular farms have performed. And every farm is going to be different. It will depend on the type of farming, the level of equipment that the land and buildings that the landlord provides and the tenant provides. There is a note on how to deal with requests for changes in rent on our website. I'm talking about changes of rent because of the acute situation that a tenant farmer may be facing just at the moment, not the usual rent review procedures, which will continue to run on. I think it's important that landowners engage with their tenants, and I think it's equally important to read the tenancy agreements properly. It's not just farm business tenancies that can be quite variable. There are clauses within the Agricultural Holdings Act which also can change quite a lot. If a tenant requests a reduction in rent or a deferral of rent for this particular year, you should also ask for details to support that request. And I think importantly, only reach agreements that you are happy with. And I think you want to keep this under review. Things change. Yes, it was a bad winter. It was a very dry spring. What's going to happen when we come to harvest? I'm not sure. Will the second cut of silage be better than expected? As a result of the first cut being below par. So I think you need to keep these things under review constantly to make sure that that you're fair and up to date. And I think it's important that you detail any agreement that is reached as a memorandum, so it is quite clear between yourself and the tenant where you lie, where the agreement lies, and how that's going to be resolved going forward. My next slide deals with up and coming challenges. I think what I want to say, just a few words about the agricultural support changes. I think if you look at, in England, you're looking at significant reductions in basic payment scheme starting in 2021. We would like this to be delayed because the environmental land management scheme is not going to be in place for some time, and we want to ensure that there is a continuation of payment going on. So that's one of our focuses on the agriculture bill, is to get a better transition for England. Wales is slightly different. There aren't any basic payment reductions at the moment because the Welsh government's still looking at the funding arrangements that they're going to get before they're going to set out a clear strategy. But they have got an agricultural bill modelled for to go into the Senate on the May 2021. So that's there, and the whole thing is to move support from direct payments through the basic payment scheme to a payment for public goods model. As I said, that's going to be ELMS in England, and it's going to be sustainable land management in Wales. So we need to take account of that. And there's also the enthusiasm to plant trees. The agriculture bill is currently in the House of Lords. And I suppose the key elements I've put down here, the third party determination and arbitration, that's just to iron out the anomalies that didn't work through as part of the Regulation Act. So, but it also widens the arbitrators to a wider group of people, including the CAV and the Agricultural Law Association. Changes to tenancies, conditions of tenancies, this is going to be quite key, and this is something we're quite concerned about. It enables the tenant to go to arbitration to get changes of tenancy, so he can comply with new financial schemes. I can pick up the others by way of questions. Trees and tenancies, this is a big issue. Do you agree if a tenant wants to plant trees or a landlord wants to plant trees, are you serving notices or are you reaching agreement? You need to consider, particularly if a tenant requests to plant trees, you need to think about values, both rental values and capital values. You need to consider the location, and actually more importantly, at the end of the day, you need to know what's going to happen at the end of the tenancies. If you're planting trees today, they will extend beyond the term of almost any tenancy. So there needs to be some provision to deal with that. And there's lots of things in the meantime, planting maintenance and funding. And I think it's important that those are all considered as part of the agreement. Planting trees on tenanted land, whether that is by the tenant or by the landlord, is far from simple. So there needs to be plenty of lead-in time to reach those decisions. And what we are doing is trying to work out a guidance note, which will be common between, I hope, the CLA and the Tenant Farmers Association, really to look at how landowners and tenants can approach tree planting, to just really highlight things that need to be discussed, and to ensure that proposals can proceed as easily as they can do, bearing in mind that, as I said, trees is a big change of land use, but there's also a lot of political capital tied up in this, because trees can deliver so much in terms of carbon, as well as sort of landscape and flood alleviation, etc. So trees are going to be increasingly important, and I think we need to make space for those in the way we agree things going forward. Thank you very much for listening to me, I would like to hand over to my colleague now, Roger Tetlow, who is CLA Senior Advisor, Senior Legal Advisor. Thank you very much.
Thank you, Andrew. Good morning, everyone. I'm Roger Tetlow, and I'm one of the in-house CLA solicitors in the legal team. We're a team of 6 legal advisors who are available to give members a range of advice relating to rural land ownership issues, covering such aspects as advice on agricultural tenancies, residential tenancies, and business tenancies, employment contracts, contract disputes, property disputes, and all aspects of public rights of way and other access issues. I'm today planning to discuss 2 issues of topical interest. The first is restrictions on the ability for landlords of commercial premises to recover rent during COVID-19. And then secondly, the new UK Commercial Property Code, which was published last week, which is designed to promote collaborative landlord and tenant relationships during COVID-19. So turning to the first of those 2, and the Coronavirus Act 2020, I expect many of you are already familiar with this, which was first enacted in March and set to run until the 30th of June. Section 82 prevents landlords from terminating business leases by forfeiture for non-payment of rent. It applies to England and Wales. The provisions originally applied up to the 30th of June, but they have now been extended until the 30th of September. The restrictions also apply to forfeiture by the landlord instructing a bailiff to change the locks, as well as court proceedings. The Act applies to, quote, relevant business tenancies, unquote, which is defined as a tenancy to which Part 2 of the Landlord and Tenant Act 1954 applies. That's the overwhelming majority of all business leases, be they contracted out or those that enjoy security. The restrictions apply not only to rent, but any sums payable under the tenancy, including insurance premiums, service charges, and interest. They impose limitations on the use of CRAW, that's the commercial rent arrears recovery arrangements, restrictions on statutory demands, and winding up petitions. It imposes, so landlords are prevented before the 30th of September from instructing enforcement officers to recover arrears of rent unless at least £189 of rent is outstanding. These extended deadlines are no real surprise given the extent of financial difficulty currently experienced by many tenants, particularly those in the retail, hospitality and leisure sectors. These interventions do not in any way write off rent for the March and June quarters, which remains due and owing. Tenants will still need to find the means to satisfy these debts once the 30th of September deadline is passed. That is, of course, unless the deadline is extended once again. Now, turning to the new code of practice for the commercial property sector, this can be found on the gov.uk website. The web link is in the slide, but if you put it into Google code of practice, it will come up. It's only a few pages long. I think it's 24 paragraphs in total, and it's well worth reading. It was developed in collaboration between the government and leaders in the sector. Some of those are listed there, and it's been endorsed by a great many of others, associations and organisations, including the CLA. The code is intended to help guide and encourage all parties to work together to protect viable businesses and ensure a swift recovery. It applies across the UK and will be in operation for a year. It's designed to provide clarity and reassurance for businesses when discussing rental payments, and to encourage fair and transparent discussions between landlords and tenants to achieve collaboration and cooperation within the sector and help to ensure no one part of the chain shoulders the full burden of payments. The code is voluntary. It does not change the underlying legal relationship or lease contracts between landlords and tenants. It encourages tenants to continue to pay their rent in full if they are in a position to do so. So the emphasis again is likely to be on the retail, hospitality and leisure sectors, which have so far lost a full quarter's trade. It advises that other tenants should communicate with their landlords and pay what they can. It suggests that where landlords are being asked to agree to concessions, that tenants should be prepared to provide evidence to support and justify any requests, and also to make reasonable concessions of their own, such as perhaps agreeing to extending the lease term in return for rent deferment, or perhaps in another way, a tenant agreeing to give up a break clause that he might have in his lease. The code provides a non-exhaustive list for landlords of the kind of things that landlords should think about when considering a tenant's request to renegotiate the rent. These include, amongst others, the closure period impacting the tenant's business and ability to trade by other means, the duration and extent of restricted trading, extra costs and obligations through protecting customers to adhere to social distancing, the needs of other stakeholders, such as banks, employees and tenants. Tenants have a lot of other obligations besides their rent to their landlord, of course. Any government support that's been received by the tenant and how this has been used. The tenant's previous track record under its lease terms. And there is also a list of the kind of arrangements that the parties could consider making. The code says landlords should grant concessions to affected businesses to the extent they can, having regard to their own financial commitments. Any refusal to grant concessions should be accompanied by a reasonable explanation. It encourages both landlords and tenants to engage with their lenders and to seek flexible support in relation to their existing financial arrangements where this is needed. And the government has said that it continues to work with lenders to ensure flexible support is provided to commercial landlords, including payment holidays and restructuring facilities. UK Finance has confirmed its members' continued support for commercial landlords, landlord customers, which includes Amendment 2 facilities and capital pay payment holidays. And so, in conclusion, it will be interesting to see if the Code of Practice leads to greater transparency and collaboration between parties. And it remains to be seen whether the Code of Practice provides sufficient comfort for landlords, given that compliance is voluntary, whereas tenants benefit from extensive protections set out in Section 82 of the coronavirus, as we saw previously. There is a friction between the two. And it's worth noting that before the code was published, many landlords were already proactively seeking to engage with tenants and agreeing deferrals, and in some circumstances where it was felt warranted, agreeing to concessions in order to support tenants' businesses. That's the end of my session. Thank you very much. I am now handing over to my colleague, Hermione Warmington.
Good morning, everybody. So my name's Hermione. I'm a policy advisor in the Property and Business team, usually based in the London office and currently working from Somerset. Oh, I've skipped on a bit, bear with me. Okay, so this morning I am going to be talking about energy performance certificates and the minimum energy efficiency standards in commercial buildings. I have 10 minutes to run through this, and it is quite a technical area, so it will be a bit of a whiz through. But at the end, I will direct you towards a new guidance note, which has recently been published, which includes everything I've spoken about today and a lot more detail. So I'll show you how to find that at the end. So, does your property legally require an EPC? This is the best place to start when thinking about the energy efficiency of your buildings. That's because EPC legislation is separate from MEES legislation. And if your commercial property doesn't legally require an EPC, then it won't legally be required to comply with MEES. It won't need to meet any minimum standards. So before getting confused with MEES, the first thing you want to do is look at its status to do with EPCs. To do that, I've put together 4 questions which are useful to look at with respect to your property, and I'll just run through those now. So the first question, this actually covers EPC exemptions. So is your property any of the following? And there are 6 EPC exemptions, so you can have a quick look through those. But I've put one in bold, which I think will probably be the most relevant to you listening. That is an industrial site, workshop, or non-residential agricultural building that doesn't use much energy. Now, doesn't use much energy, what that means in practice is it doesn't have heating. So taking a workshop as an example, if you let a workshop connected to power, so there's lighting, there's electric sockets, but there is no heating, that won't require an EPC at point of letting. Now, a recent inquiry I got was from a member who said, I let this workshop without heating, but my tenants brought in portable electric heaters during the winter. This is a bit of a grey area, but what I've said that if at the point of letting, your workshop doesn't have heating, then it will not require an EPC. So that's the first thing to look at. The second question is, has your property been built, let or sold since the 1st of October 2008? If it hasn't, then again, it doesn't legally require an EPC. And I've put the let part in bold here. just to expand on that slightly. Now, a lease renewal or a lease extension or a rent review, that will not trigger the requirement for an EPC. So it's really just, have you had a new tenant with a new tenancy come into your building from the 1st of October 2008? And if you have, that will trigger the requirement to get an EPC. Sorry, my slideshow isn't moving on. Sorry about this. Okay. I'll blame my rural location and my poor internet connection. So I just want to go back. So if we have a look at the third question to look at is the tenancy granted for a term not exceeding 6 months or for a term of less than 99 years? Now, this isn't a loophole. You can't keep on granting 6-month tenancies to your tenant to avoid getting an EPC. It has to be a genuine 6-month let with no ability to renew or extend. And lastly is your property listed or within a conservation area? I know this is really relevant to a lot of our members because you have a lot of designated buildings. This one is quite complicated. They're not necessarily exempt. You do need to look at each of your listed buildings individually, but I will direct you towards the new guidance note because there's a whole section on the CLA's recommended approach to listed buildings and buildings within a conservation area. And I would recommend having a look at that because it might be that your property falls outside of EPCs and therefore doesn't need to meet any minimum standard. So let's see if I can move on. Or if I can ask our event manager to move to the next slide for me. Thank you. So if you've looked at these 4 questions and your property does legally require an EPC, then the next thing to have a look at is whether that property needs to meet the minimum standards. If you are familiar with domestic MEES, you'll know that the regulations list relevant tenancies. Now, that isn't the same for commercial. For commercial, all tenancy types are covered. So if you let a non-domestic building to a tenant under a tenancy, and it legally requires an EPC, then you will need to meet the minimum standards. Just to note here as well, that doesn't include licenses. So if you have a license, that won't fall within MEES, but it's probably best to check that it is actually a license rather than a license in writing, but a tenancy in practice. So the minimum EPC rating is E. So from the 1st of April 2018, new tenancies granted will need to meet a minimum EPC rating of E or have a valid exemption registered. And this will then go on to apply to all existing tenancies from the 1st of April 2023. I know that sounds like quite a long way away, but it would definitely be important to try and plan for this, and there will be cost and time associated with meeting these regulations, so it's always useful to get ahead of any deadlines. If we could move on to the next slide. So I'm going to talk about the exemptions now. The main exemption is the 7-year payback test. Again, if you're familiar with domestic MEES, you'll know that the government doesn't expect a landlord to spend more than £3,500 improving their property. There's a different way they've approached it for commercial properties, and that is the 7-year payback test, which is a lot more complicated, frustratingly. But simplifying it down, it means that if your savings from the energy efficiency measure you've installed over 7 years are less than the capital cost of installation, then that will fail the 7-year payback test, and you can register exemption and you'll be exempted from meeting the minimum standards. It's quite a complicated calculation. You need to have, it doesn't just look at one measure, it can be a package of measures. You need to get 3 quotes from 3 qualified installers for the different measures. It's advised that you use a level 4 accredited EPC assessor to undertake this calculation. I actually don't have any personal experience doing this payback test, and I would be really interested to know if anyone listening does, because I'd love to understand how it works practically as well as just in theory. It would really help our lobbying with proposed changes we want to make in this area. So if we could move on. So as well as the 7-year payback test, there are 5 other MEES exemptions. So if you could just click through the 5 now. Again, if you're familiar with domestic MEES, these are the same as for domestic properties. You can click through all 5 of them, sorry, thank you. And yeah, each exemption requires evidence to be submitted. So with an EPC exemption, if your property is exempt from requiring an EPC, you don't need to do anything. You can just carry on. Whereas if your property benefits from a MEES exemption, you need to register that on the PRS, the Private Rented Sector Exemptions Register. This is a self-certified register. Once you submit your application, your exemption is live. Your corresponding local authority will be notified. It's up to them if they want you to have a look at your application. They might get in touch saying they need a bit more evidence or a little bit more information. And a MEES exemption lasts for 5 years. So if we could move to the next slide. And thank you. So this is the new guidance note. If you have commercial properties that you think might either need an EPC or comply with the minimum standards, I would really recommend having a read of this guidance note. The easiest way to access it is if you log into your account on the CLA website and then type in the code into the search bar. That should bring it up. If we could move on, please. Yeah, I'll just say thank you. I'm really sorry about the technical errors, but I'm obviously happy to answer questions in the Q&A afterwards. And then beyond that, please do pop me an email or give me a call and I can give you tailored advice if you need any. So thank you very much.
Good morning. My name is Matthew Haig. I have been working for Stratton Parker for the last 9 years in our estate and farm management team, initially in East Anglia and more recently in Berkshire. Hopefully my internet connection is slightly better and reliable. During this presentation, I hope to be able to provide a brief overview of the changes taking place at a policy level and how these may impact on the 2 principal forms of tenancy agreement under which land is farmed: Agricultural Holdings Act leases and farm business tenancy agreements. I'll then go on to draw some conclusions. Firstly, though, I just wanted to touch on actually how big is the let agricultural sector. Agricultural land represents the majority of land use in England, extending to about 17.6 million acres, with a further 3.5 million acres of natural land, which includes woodland, coastline, other non-farmed areas, for which farmers are often responsible for management. These non-farmed areas may have a growing importance going forward in the new world of natural capital and public money for public goods, areas to which little value may have been apportioned in previous tenancy agreements. In terms of the let sector, approximately 1/3 of the total farmland in England is under some form of long-term agreement. And since the introduction of farm business tenancies in 1995, the area of let land has increased, and the split between old AHA leases and FBTs is now roughly equal, according to the CAV's last survey. Both landowners and tenants have benefited from the additional flexibility. So what's changing at the moment? As we should all be aware, we are in the middle of a once-in-a-generation change in farming policy following our withdrawal from the EU. The Common Agricultural Policy currently funds UK agriculture to the tune of £3.5 billion per year, and this accounts for a reasonable portion of the profitability in farming at the moment. The slide indicates just how much of the total income per farm is underpinned by direct support, with grazing livestock being particularly at risk of losing state funding. These figures are from DEFRA's 18-19 dataset, which is the most recent one published, and this shows an actual improvement from the previous year in terms of agricultural income, when direct support was even more important to profitability. The profitability of farming is obviously directly linked to farm rents through most rent review mechanisms, so changes to farm support will impact on the let market. The agricultural bill itself will be creating an entirely new policy framework for UK agriculture, and is currently passing through the House of Lords. There are a number of areas covered by the bill, but from a purely financial standpoint, the bill makes provision for a 7-year transition period with direct payments progressively cut until 2028, is the current thinking. We do know that next year there'll be reductions applied to claims, depending on the value of that claim at the moment, but there is no detail yet on how reductions will be phased over the next 7 years. The bill also makes provision for payment to farmers for environmental management through ELMS, which will in effect replace direct support, although it is unlikely to equate to a similar level of income. So what does this mean for profitability? Our research department produced a very good paper last year entitled The Funding Gap, which I would happily direct you to look at on our Rural Hub page. This modelled the potential decline in farm profitability over the next 7 years following the removal of direct payments. The model on the screen is based on a number of assumptions, including that BPS is reduced on a straight line basis and that ELMS is a more profitable scheme than countryside stewardship. In case you can't see it, BPS is shown in red, agri-environment payments in green, diversification in blue, and farm income in yellow. The models are then broken down by farm performance, top, middle, and bottom performing farms. This would support what we already know, that the worst performing farms will probably be forced out of the industry, as has been the case in other countries that no longer directly support the agricultural sector. That is, of course, unless ELMS is a more beneficial scheme than we're currently being led to believe. In light of this, the Agricultural Bill proposes some changes to the Agricultural Holdings Act. Andrew has touched on these already, but the focus of these changes is to increase productivity in the let sector. Just move that slide along. It'll be interesting to see how the market reacts to these changes and how rent reviews are handled over the next few years. Ooh, I've gone way too far there. The other significant area on which the government are consulting is the proposal to capitalise BPS payments into a one-off payment. In most cases, in an AHA scenario, the entitlements will belong to the tenant, and a capitalised payment might result in some tenant farmers deciding to retire earlier than they might otherwise have done so, particularly if the farm is heavily reliant on BPS at the moment. However, if the tenant doesn't retire, but does capitalise the payment, should the value of entitlement still be considered in the rent review calculation? The rent review is based not on what the current tenant is doing, but on what a typical farmer might be expected to do with the holding. So we could have a scenario where a tenant no longer has entitlements, having capitalised them, but is having to pay a rent based on the typical farmer having them. We'll obviously need some more clarification on that. As a firm, we've been doing a lot of work in the last 12 to 18 months in terms of the Farm Business Tenancies Act, in order to protect our clients' interests going forward, given the raft of emerging opportunities for landowners and some of the changes being proposed in the Agriculture Bill. We have included clauses in all new agreements which are designed to prevent tenants from being able to capitalise the value of the BPS claim if that provision were introduced. In addition, we have also included clauses to allow landowners to obtain vacant possession of part or all of the holding if the land is required for natural capital purposes, or ELMS, if landowners wish to enter into some form of scheme themselves. Of course, depending on the nature of the scheme, it may very well make sense for the tenant to enter into it and for it to form part of the agreement, but we don't have any detail on ELMS yet. Aside from the Agriculture Bill, the Environment Bill is also working its way through Parliament. Amongst other things, this proposes the introduction of biodiversity net gain, which could require developers to offset the environmental losses from developing land and enhance them by around 10%. Landowners could benefit from entering into agreements with developers to offer these services, but will need the ability to obtain vacant possession to do so, which will require provision in the agreements. In terms of the FBT market and rental levels, I have found the vast majority of our clients want to ensure good long-term relationships with tenants are maintained. It is rarely about maximising the rental return, particularly for private clients. The average length of term being granted for an FBT is around 5 years, which gives a degree of confidence to both parties and allows the tenant to invest properly in the management of the holding. However, the big question at the moment is how do we agree rents when there is so much uncertainty, particularly if they are being set for 3 years? Not only is there no clarity from the government yet on how direct support may change, but we also have the potential impact of trade negotiations with the EU and US hanging over the industry, which could have an equally dramatic impact on profitability. With the loss of BPS, I expect there is going to be significant pressure to reduce rents in many cases. However, the market is more complex than simply being linked directly to subsidy. BPS has probably created more uniformity in the let sector than there should be, with less variance for land quality and demand. What we know from our farm benchmarking work, which I have to say is predominantly focused on arable farms, is that the top 25% of farmers can run a very profitable agricultural business. It'll be these farmers that will drive the demand for land, and an FBT represents one of the easiest ways for them to expand. Therefore, I do think there will be a greater focus of the market on the profitability of land holdings based on its quality, and there'll be much more localized issues around supply and demand for land, as farmers either expand or drop out of the industry. This will mean that professional advice from those that understand the changing marketplace will be more important than ever. I expect there will be an increasing number of demands for the use of land aside from solely food production. This will represent opportunities for both landlords and tenants going forward, but as ever, open and honest dialogue between the parties is key to successful agricultural tenancy management. Where there is less flexibility under older AHA leases, the government are trying to address this through the most recent round of reforms to reflect the changing market. But generally, we do think that anything that needs to be implemented should be made by agreement, rather than having to rely on statute and legislation. Thank you for listening. I'll hand over to Carl from Barclays, who's the National Director of Landed Estates, and is now going to provide a presentation on agricultural leases.
Thank you, Matthew. And thank you, CLA, for putting these events on. So as Matthew said, my name is Carl McConville and I head up Landed Estates at Barclays Bank. I've got just 5 minutes before the questions and want to talk quickly about what your bank needs to know and why they need to know it in relation to commercial and agricultural tenancies. I'm going to cover 3 areas: granting, amending, and voids. So when looking to grant or amend a new tenancy, you need to think, first of all, is this asset mortgaged to the bank? And if it is, then your bank will want to know about it, as the granting of that tenancy is likely to affect the value positively or maybe negatively, which will impact on loan to value and have other knock-on effects within the banking relationship. The granting of a tenancy may also affect the bank's ability to rely upon that tenancy or its desire to ever use that asset in a collection situation. So they'll want to understand the terms and the tenant before consenting to it. And if the lease is for a longer period, the bank will need to agree to the lodging of that tenancy at the land registry. Any bank will want to review the terms and possibly suggest amendments if the proposed terms are detrimental to the bank's position. Some banks, hasten to add not Barclays at this moment, make a charge for this review and consent, and that will potentially slow down the making of any changes you want to make. I always say to clients that assets that change tenants often or are likely to have significant changes to their legal status shouldn't be charged to the bank if at all possible. That keeps the flexibility within the business's hands to make those changes and to move at speed. However, often we do have to charge those assets to support the business in the funding that it requires. And where that's the situation, I suggest to customers that they communicate early with the bank and make sure that we're fully aware of what's changing and why. Further, when looking to amend or grant a lease to non-mortgage property, I always suggest to customers and clients that they need to think if this may impact on the value, the access, the ability to monetize mortgaged property. And again, if you think it may, then talk to your bank early. Because when you have a new valuation in 5, 7, 10, 20 years' time, you really don't want surprises at that stage that the value has been impacted by decisions that have been made that haven't been communicated and shared. In relation to voids, there's likely to be no formal requirement to let your bank know. However, bankers are a conservative type of people and don't like surprises. And I'd encourage you to speak to your bank if sizable voids or periods of non-payment are experienced or expected, because ultimately this will affect your ability to service your debt costs. You know, you're going to have associated reduced income, and that's going to create difficulties for the business. So discussing this early will avoid unexpected covenant breaches and will allow you to think about the best way to fund any shortfall. As Roger discussed earlier, the banks are here to help and are well primed for this situation. It may be that the business can cope without that income for a short period, or you may wish to apply for a capital repayment holiday, a bounce back loan, or a COVID business interruption loan, or just ask for a small overdraft facility or increase to an existing overdraft facility. Any of those ways, I would just suggest that if you think there are going to be voids, or you know there are going to be voids or non-payment of rents, get talking early so that we can make sure that these facilities are put in place in good time so that it doesn't impact on your business's ability to trade. Although you want to be fair to your tenants, you're not their bank. You're not there to provide them with sources of funding. That's their bank's problem and position. Finally, we understand that variations to tenancies are required and are very much here to support. And my team will always welcome being engaged early so we can ensure that the changes proposed meets everyone's requirements. With that, hopefully we've caught back up. I'm going to hand back to Dorothy for some questions.
Carl, thank you for that. That was really great and wonderful to get us back on time too. So we have got some questions, and shall I maybe start? Sorry, I should have asked the panellists. Will all the panellists turn on their videos and their microphones? Good. That's everybody there. And so if we start on questions, Roger, can I start with you? Does Section 82 of the Coronavirus Act mean that it's impossible to evict the business tenants whilst the provisions remain in force?
Thank you, Dorothy. I think I heard you, but you were breaking up a bit then, I think. And I hope you can hear me clearly. The answer is that Section 82 does specifically mention that landlords cannot forfeit a lease because a tenant is in arrears of rent. So if there are other covenant breaches taking place, say a tenant has unlawfully assigned the lease to a third party, then in those circumstances, the opportunity is there for a landlord to take court proceedings and forfeit the lease. It's also, it should be remembered that landlords and tenants are able to negotiate between themselves for the surrender of a lease, so that if a tenant really thinks his business is no longer going to be viable, he can't see himself, or the level of debt he's going to carry after the lockdown has ended is going to be so monumental that there's really no point in trying to carry on trading, then in those circumstances it's in both parties' interest to try to negotiate a surrender of that lease, so that the landlord has got the opportunity then to try to re-let the premises, provided of course that there's a suitable tenant there in the taking.
We've got Andrew, a question for Andrew here about forestry. Question is, as forestry is so long term, is it better for an AHA tenant to surrender any land to the landlord for tree planting? The suggestion is that it's another example of 1976 Act being totally unfit for purpose.
Thank you very much, Dorothy. If I can just outline, in case you didn't hear the question that was put to me, it was about forestry being long-term. Is it better for an AHA tenant to surrender any land to the landlord for tree planting? And then secondly, is the government going to wake up to the fact the 1986 Act is on foot for purpose? I suppose the answer is, to the first part, is that yes, forestry is long term. I suppose it depends what sort of tree planting you're thinking of doing. If it's big blocks of trees, when it might be, the landlord might be better placed to deliver that, or will be better placed to deliver that. If it's small field edge planting along hedgerows, planting a shelter belts, that perhaps is something that that the tenant might be prepared to do. Then moving on to, the 86 Act being on fit for purpose. It was founded in post-war legislation and post-war agricultural policy, so it is outdated. We've also got the 1995 Agricultural Tenancies Act, which deliver farm business tenancies, which is much more up to date and a much more practical way to continue. However, clearly there is a considerable amount of interest and tied up in Agricultural Holdings Act tenancies. There is not only the aspiration of being able to continue for the rest of your life, but also in some cases your children or your spouse continuing for another succession. So what the government has done is really tried to introduce some changes that would give a bit more longevity to those agreements. However, we did fight hard to stop assignment of Agricultural Holdings Act tenancies because we felt that was just prolonging it for no reason. There are changes at succession criteria around the commercial unit test, but also, interestingly, the business suitability test, which means that a tenant who wants to succeed will have to go a little bit further at justifying his business capabilities, perhaps beyond just those of running the agricultural business. I hope that goes some way to answer that question. Thank you.
Okay, I will jump in and answer the next question, which is from Jack. Thank you. Would an assignment of a commercial lease mean an EPC is required? So yes, assignment does trigger the requirement for an EPC, as does subletting. So assignment or subletting, when there's a new tenant really that starts, an EPC is required.
Fine. I've got another question here from Mark Strawson, who asks, when do you expect FBT rents to fall and by how much? Apologies for my screen. It appears I'm coming from the 1970s with the quality of picture there, but I think it's just a trick of the light. I think BPS is just part of the picture, and I would err away from linking rent directly to the direct support. We're going to be entering a much more complicated phase, I think, of the subsidy, whereby if it is altered depending on the value of people's claims, different claimants may have different payment levels depending on who they are. So there'll be pressure on rents, but I suspect there'll be greater variability depending on local supply and demand for land. And in addition, if in 2024 the ELM scheme is very beneficial for certain parts of the farm which may have previously been deemed unproductive, then more value may be applied to them than it is now, which might support rents. So I think it's a more complicated picture than when will they fall and by how much. There's a lot of things to consider in the market.
Thank you, Matthew. Will people put their thumbs up or down or something if I'm still sounding like a Dalek? Am I okay? Yeah. Right, thanks. I don't know what went wrong then. How are we doing with the questions?
I'm happy to take another question on EPCs and MEs. So I've been asked, if I let an industrial shed to a single tenant with, say, 90% storage with no heating and 10% office with heating, does just the office area require an EPC? The answer is yes. You can have an EPC on part of a building, and this is a really good example of when that would apply. So, and if you need an EPC, so if that office area has been let post 2008, you will require an EPC, and then it might also need to comply with MEs, again, if it meets the criteria that I spoke about. So yes.
Okay, thanks, Manny. Were there any other questions? Right, because I logged off and back on, I can't see the questions anymore. So if anybody sees a question that they would like to answer.
The new question just come in from Mr. Roberts. I hope one of the surveyors here might help with answering this. If I just read it out. In the current climate, do you think a Section 25 notice, that's a notice served by a landlord or a tenant, actually, Section 25, to renew a commercial lease, should it be served as soon as possible or delayed? Any takers for that? I mean, my view would be is it's going to depend on where you think the current letting market is at the moment, as to whether you're intending to allow the tenant to stay, but it's a delicate balance to decide whether you just allow the existing lease to carry on untouched, or proactively go in there and serve a notice saying, I wish to renew the lease. And it really depends on your take of the property market at the time as to whether you make that decision or not, I think.
I would agree. I think that it really depends on the type of commercial unit you're talking about. You know, some businesses may have actually had quite a good last 3 or 4 months, whereas others may have suffered disproportionately. So it will entirely depend on what you're dealing with, I think.
Anything else? And Andrew, did you you rather cut short your agricultural bill schedule 3 section of your talk? Did you want to just quickly say a few more words on that?
Yes, thank you very much. In sort of brevity, I tried to cut that back a bit. But yes, I mean, there's the ability of the tenant, as I say, to go to arbitration on changes to conditions of tenancies, so they can comply with new schemes, and that's provided for under clause 7. There's also the ability for landlords to undertake and fund improvements on and basically finance the tenants' improvements. And that to be excluded from the rental assessment. So that is also quite useful. That will enable landlords who wish to invest in tenant holdings and basically charge a finance charge to the tenant. Changes to succession criteria, I sort of dealt with that sort of fairly briefly. The government has wanted to escape from the commercial unit test for quite a long time, mainly because I think they don't like preparing the units in production order every year, but also the fact that the commercial unit test can bite in different ways, and it is able to be circumvented with good planning. As far as the age of successor is concerned, at the moment you have to wait till the age of 65. That will be removed, so you can actually succeed to a tenancy at any age, providing you meet the criteria. There is also changes to Case A notices which cover county council small holdings, where there was a retirement age of 65 in there, and again that is now just referred to as a retirement age, i.e. the age you would be able to draw your state pension, not the age of 65 necessarily, which gets over some of the issues regarding age discrimination. So that's sort of by way of clarification. So I hope that is of some help expanding on that Schedule 3.
Yes, no, that was useful, Andrew. I think we've probably reached the stage where I ought to wrap up this webinar. I'd like to really thank all the speakers for coping with the technology difficulties, including my own. And I think we've had some really good sort of heavy duty content in this webinar this morning. And I'm sure those attending have learned a lot. So I really would like to thank the speakers. I think our particular thanks are due to our sponsors, Stratton Parker and Barclays Bank. We genuinely appreciate their support. And finally, I would like to thank all those of you who've attended this webinar. I hope you found it useful. And I'd like to draw your attention to our next webinar. I think there should be another slide coming up somewhere. Our next webinar, which is on water and climate change and water and climate change adaptation. This is taking place next Wednesday at 11 o'clock, and I do commend it to you. So thank you very much.